and requesting that this be a Lebanese-run show, very similar to Sierra Leone that John Kameh will speak to you about this afternoon. That's a court set up by a Sierra Leone Act of Parliament. And that's what they wanted here, a Lebanese Act of Parliament and a Lebanese responsibility, but with an international dimension to give it authority and to ensure it was a fair and proper judicial system. In Resolution 1664 of 2006, the Security Council agreed with that and requested the Secretary General to go ahead, negotiate with Lebanon and set up this court of international character. So those negotiations took place between March and November 2006. The UN legal team, some of whom had been responsible for the Special Tribunal, as well as setting up international courts in Kosovo and with a history of Rwanda, Yugoslavia, put together a Lebanese fitting model so that it could work for them, but to be under the Lebanese system. And that matter, after a great deal of negotiation, was agreed as between the UN and the Secretary General, and a statute for the court that was to be established was provided by the UN after these negotiations and shown to the Security Council for its approval. So there was going to be a treaty between the UN and the Lebanese Republic, and a statute that the Lebanese would then put into their legal system, pass as a law, and the work of the tribunal could begin. That was agreement between the government of Lebanon and the UN. When it came to ratification by the President, Lahoud, who was a long-standing Syrian protege, he refused to sign the treaty. And that meant in international law, all bets were off. If the head of state doesn't sign the treaty, it is not an international agreement. And for the want of that signature, the whole thing failed, as between the UN and a nationally based prosecution system. So Kofi Annan went back to the Security Council, told them of this failure, and straight away they passed Resolution 1757, 2007, and that resolution took out from Kofi Annan's report and the draft agreement and just made it law. Bang, straight off, right, they won't be able to do it. We ourselves will establish a UN ad hoc tribunal. So we moved from national suddenly into this being an international court, and it is the first international court for the second tier of crimes that are terrorism, rather than being crimes against humanity, war crimes, the universal crimes. And so this route and extension of authority by the Security Council to create an ad hoc tribunal for what is really a national-based offence was a historic moment, and indicates the growth in this market that we have seen move from being universal crimes alone, now being national crimes as well. Many commentators thought that this was unlawful. The door tenant of ours in Chambers, the very eminent Professor William Shabus, wrote on his blog that there's no authority for this, etc. I disagreed, and the route we're going on now is the route that I said to him was how this comes about. It's law, and until someone challenges it, someone will have to challenge it, maybe in the first case. They'll lose, go to appeal, they'll lose there, but the point will be made. Measures were taken to enact that statute, which became the UN Ad Hoc Special Tribunal for Lebanon. Just under there, so that you could see it, why I put this slide in, you see Chapter 7, where the authority comes from, this crucial document of the Charter of the United Nations. Chapter 7 is where this power derives from, and that's what they acted under. The jurisdiction of the tribunal was primarily, if I put it that way, because that's where it started, with the death of Hariri and the death or injury to other people at his crime scene. And then it was also extended that if the tribunals finds that other attacks had occurred in Lebanon between the 1st of October 2004, 12th of December 2005, or any later date, decided by the parties. So the defence might be deciding, they think, that, oh, you can have another tribunal, you can have another assassination after this date, we'll agree to that being part of your jurisdiction. I think they must be very, very naive, that any defence counsel, don't look in shame if you thought it would be a good idea, would agree with that. And that those attacks, if they were sufficiently grave and of a similar nature, would be part of the jurisdiction of the court. So moving from Hariri specific to a far wider net, which by this time was about 13 related terrorist explosions. Criminal law to be applied under Article 2, the Lebanese Criminal Code. Lebanon at this time had the death penalty, but that was repealed. The Lebanese Criminal Code, in fact, in its Article 1, has a provision that prevents retrospectivity of criminal offences. There is a clash here immediately with the Lebanese Criminal Code, which did not have these kinds of provisions we're seeing from the Lebanese tribunal incorporated within it. Article 3 is another potential clash in individual criminal responsibility. Lebanese Criminal Code didn't have within its provisions the concept of what we call command responsibility, where a superior would be liable for the acts of those beneath him if it was foreseeable that they might go and commit offences, and didn't take necessary measures to stop them committing crimes. So a general who's aware that his troops beneath him might plot the assassination of Hariri, or the president who might be aware that his military generals might plot the assassination of Rafik Hariri. So the concept of individual criminal responsibility, including superior responsibility. There we have it there in subsection 2. coffee break. Yeah, no, I'll finish this, then we'll have a coffee break before David Young. Superior responsibility is set out there, essentially lifted from the International Criminal Court, and they've just dropped it into the Lebanese judicial system. Although Lebanon is not a party to the Treaty of Rome and a state signatory of the International Criminal Court. So a whole bundle of issues here that in my view are ripe for challenge over the jurisdiction of this court. And again, you see spelt out the fact that the person acted pursuant to an order of a superior shall not relieve him or her of criminal responsibility, but may be considered in mitigation. Lebanese courts can have a concurrent jurisdiction with the ad hoc tribunal, but the idea is that the Special Tribunal for Lebanon will have the superior jurisdiction. So any of these cases could go back to Lebanon, but if the Lebanese Special Tribunal decided to take a case, then that, as the superior court, would be able to take over the proceedings from the national court. Usual principles of all legal systems and international law, non bis in idem. If you've been tried elsewhere for the same offences, you can't be retried by the other court. So if you've been put on trial at the Lebanese tribunal, you can't also be tried in the Lebanese National Court, and vice versa. In international law, in fact, this is stretched to a fairly ludicrous degree, and their concept of non bis in idem, as applied at the International Criminal Court, has some very, very dodgy jurisprudence. There is examples of, in the Katanga case, where he was the subject of proceedings in Democratic Republic of Congo, lifted out of there, put at the ICC, really on the same matters, one extra charge, other charges not the same. Court said, oh no, we can take jurisdiction of it. No judges ever taking the trouble to vote themselves out of work and out of employment, was my view, looking at that particular piece of jurisprudence. The suspects in Article 15 during investigations have the rights accorded in all international courts, lawyer, legal assistance. All of this comes out of the framework of the ad hoc tribunals, right of silence, right to legal advice, etc., right to call witnesses, prosecutor to prove guilt, onus on the prosecution, and here they've spelt it out that it must be beyond reasonable doubt. These provisions here about an expeditious trial without undue delay, to cross-examine